Adjournment request from item number 1 to 4. From item number 5 to 39. Adjournment request.
Should be the consent of the arrest for item number 48.
Adjournment slip. All right.
4th August.
Item number 14. No, I am filing the affidavit today.
1-4.
1-4. And for the appeal.
Oh, that tender was cancelled because of.
It was retendered. But
When do you want it?
but,
Have you informed the other side?
I am for that. He's for that.
As prayed for, on behalf of the respondents, let's state, let this matter come up for consideration. First week of June.
4th June.
May it please, my lord, with respect to item number 38, which was mentioned, there was an interim order that may be extended.
Normally, interim orders are extended.
My lord,
Doesn't matter.
My lord.
Unless we say that it is stands for
my
people.
lord, the date may be fixed, my lord.
Already fixed.
4th of August.
My
You
lord,
come late to the court, no?
my lord, sorry,
We don't leave any petition undated.
my lord.
You can also interim order, if any, in the meanwhile shall subsist.
Any other request?
I may appeal of it. I'd like to mention for listing one review petition. A matter relating to a constitution of Panchayat, section 18 and a rule, a constitution rules 46(3). For only clarification. Section 18 of the Panchayat Act, no convenience motion after
When have you filed the writ petition?
a review petition,
Review petition, when
Yeah.
judgment by us?
Yes,
Review next week.
Next week. Next week.
This is your lordships. Your lordships, I beg to mention for listing of a pending writ appeal, lordship. It was last posted in the year 25, lordship, 2525, lordship.
Next week.
Any date, lordship. Highly obliged, lordship.
Okay. Daily list for orders item 1 and 2.
In this case, I have been appointed as an amicus curiae. For the first time, we are appearing by the, it's a very old pending case, I think.
That's right. All the more reason for us to fix an early date.
Yes, sir,
Oh,
absolutely.
yeah.
Because,
The pleadings are complete, all paperwork has been
yes,
circulated.
according to my inspection, it transpires, my lord. We have got it, they have not received it.
Please ensure, yes, that everybody has.
I have got my, that
You
may
have
be
got
recorded.
yours. All right. So we fix it for hearing in the first week of June,
To be
or maybe
correct.
second week of June.
My informant is also not. There. So, it was quite long, my lord, with the 22.
Let this appeal along with the death reference number 1 of 2021 be listed for hearing on 8th of June. 8th of June. On 8th of June at 3 p.m. And the registry to provide the paper book to all the parties.
This is a big volume, and just after 8 minutes. In the month of June, my last part of the
It's a very, but we don't want to adjourn it further.
Copying some.
Yes. Obliged.
Item number 3.
Lordship, this is an application for condonation of delay, Lordship.
Any explanation given?
370 days delay, Lordship.
What
I have,
explanation?
Contempt.
Lordship,
2 more.
no, Lordship, here, what I have noticed, Lordship, after an instruction was issued by the Office of the Chief Minister, Lordship, for filing an appeal, Lordship, about 4-5 months, Lordship, file kept pending in the Office of the Standing Council.
Same, Mr. Patwari, same order passed earlier.
Okay, I'm placing 2 judgments, but.
I don't know. খালি এখানে লিখি থৈ দিছো নতুন আপলোড
Lots of in this, lots of here and relying upon three paragraphs, lots of paragraph 14 and 16 and 17 lots of. If lots of comes to paragraph 14 lots of. Paragraph 14 lot.
All right, yes.
Lots of paragraph 14 lots of this judgment lots. This is Inder Singh versus State of Madhya Pradesh lots.
Yes.
There can be no quarrel on the settled principle of law that delay cannot be condoned without sufficient cause. But a major aspect which has to be kept in mind is that in a particular case, the merits has to be examined. It should not be scuttled merely on the basis of limitation. That is one point. And Lordship, in this case, Lordship, two judgments were relied upon by the Honorable Supreme Court, Lordship. One at paragraph 16 and one at paragraph 17, Lordship. 16 is more important, Lordship. This is paragraph page 12, Lordship, paragraph 16. Paragraph 16, Lordship. The court in Ramsanar Shankar Devdhars versus State of Maharashtra, 1974, 1 SCC 317 held. Then there was a delay of more than 10 or 12 years.
There is no cavil at that. There is no inviolable rule that whenever there is a delay, the court must necessarily refuse to entertain.
Lordship, that is.
We are allowing most of the petitions.
Yes, Lordship,
Because on similar ground we have rejected.
Yes.
So
No, Lordship, that is why, Lordship, I have pointed out, Lordship. In this case, Lordship, Office of the Chief Minister instructed to file an appeal, Lordship, in the month of April itself, Lordship. And the accordingly file was forwarded to the Departmental Council, Lordship. Unfortunately, it got delayed in the Office of the Departmental Council, Lordship. That is one.
We have not accepted that plea in the earlier.
Yes, but that is one, Lordship. Why the merit is important, Lordship? Lordship, in terms of court's direction, Lordship, one notification was issued by the state government in the year 2020. Therein, Lordship, it was specifically mentioned that after the issuance of the so-cause notice, within a period of 6 months, Lordship, the reason order will be passed reviewing the suspension of the incumbent, Lordship. In the instant case, Lordship, a so-cause notice was issued and the reason was order was passed after 18 days.
So
Only 18 days.
We'll take a different view in different cases. The view should be consistent, Mr. Naik. That's where the beauty of the court proceedings lie. Will not make any disposition.
Lordship, in that situation, Lordship, I'm placing another order passed by our High Court, Lordship.
Please give those judgments.
Lordship, to me, Lordship, merit is more important, Lordship. That is why, Lordship, I'm pressing your Lordship.
It's true. If we had not discussed that petition, we would have considered.
No.
Now we will not take a different view. Because that appears to be, I mean, that is against our rule of housekeeping. You can challenge this order.
No, that is okay, Lord. Challenge is okay, Lordship, but at least Lordship will see the merit of the case.
We would have considered it in a different perspective if we had not passed an order earlier in the same petition with the same grounds. Now, Mr. Naik, you don't ask the court to take a different view in different matters.
Lordship, what I am praying your Lordship, at least the merit should not be scuttled, Lordship. Limitation is there.
Challenge is not defining.
No, Lordship will at least consider, Lordship, what is the merit of the case.
Consider. Discuss. We have been condoning delays of 500 days, 600 days, but only where this, because in similar matter, we have not done this.
Lordship, my submission.
Mr. Nayak, we have heard you.
Lordship,
Next
just
case.
one point.
Item number 4.
Next case.
Yes.
Your Lordship, here
Delay of
120
125 days.
Yes, ma'am.
Notice has to be.
Yes.
Respondents.
Not request.
Both modes returnable funds of date. August.
7 August. Item 5.
Notice both modes, August.
Payment August. Item number 6.
Who are the respondents?
Same respondents. Same as item number 5.
Mr. Chaudhary, you accept one. For one. Notice to respond number 1 is accepted by Mr. R.K.D. Chaudhary. Notice to response number 2 to 5 shall be issued.
2 and 5 are state respondents, Lord Sir.
No. I think they are in a standing council. Industries.
Industries no standing also is there, Lord Sir.
No.
No.
Notice to respondents number 2 to 5. Both modes within 2 weeks, returnable August.
7, 8.
Much of that.
Supplementary item 40 for orders.
Yes,
May I please also, my lord?
yes.
My lord, the order, my lord, against which contempt is a phase 19, my lord. Lordship, the respondent
Let's come to the
school,
order.
my lord. Page 19, my lord.
Yes.
In fact, the second paragraph, the learned counsel for the respondent appeal for the managing committee of Sankadev Vidyanagar, however, Kavyanga has made a statement before this court that the management of school concerned has principally decided to relook at the upper senior section after class 8 to school in question to a new plot of land. However, since the construction of the primary school going on in the existing plot of land, the school authorities need some more time to initiate the process for relocating the upper section of Sankadev, however, to a new plot
No
of land.
agreement was fixed.
My lord, yes, my lord.
It had only expectation that the managing committee shall initiate the process. Where have you said that it has not yet started the process?
I have stated, my lord.
Construction is going on.
My lord, page 9, my lord. Page 9, para 10, my lord.
Who appears for the respondent?
My lord, the
Respondent number eight.
notice not issued, my lord. Let the notice go, my lord, first.
We are not getting persuaded. It's not a case of contempt.
My lord, because, my lord, if
Where is the order? The order doesn't say anything.
my lord, pursuant to this order, my lord, in fact,
What do you mean by initiating the process?
yes, that's what, my lord.
Just a minute.
Yes,
They have principally decided
yes,
that the upper portion of the building shall be relocated.
my lord.
I think the process has already been initiated.
No, my lord,
It's
that's the
been delayed
problem.
only for the reason of the construction work going on so far as primary school is concerned.
My lord. My lord, now thing is that, my lord, the government of Assam,
Where have you stated that it has not been done?
Madam,
They are trying to revoke that decision. Where have you said?
page 9, my lord, para 10. My lord, I have stated, my lord, however, as on date, para 10, my lord,
Yes.
middle line. However, as on date, the respondents have not taken any step for
What is the
relocation
stage
by
of
obeying.
construction? What is the stage of construction of that primary section?
My lord, primary section, my lord, one
Where
grant
is
was,
the statement with respect to the stage of construction of the primary section? Then only we'll say that no steps have been taken because that space was given under the order.
my lord.
Where is that statement? Now we will
Primary-
dismiss this petition straight away, lock, stock and barrel. Unless you tell us that the construction is complete, yet they have not taken any steps overtly, which would suggest to the court that the orders are being implemented. The trust of this court
That's correct.
is being accepted. Where is your stake?
My lord, in fact, I have filed one additional affidavit, my lord.
Where is that?
Yes, additional affidavit there I have placed, my lord, and that 11/5/2026.
Mr. Das,
Yes, yes,
Mr. Das, they filed an application
They-
for extension.
yes.
And it is your stand that they are continuing with the construction, but for financial constraint, they could not complete that. And they withdrew it yesterday.
Yes, my lord. Yes.
Not now. can withdraw this petition to file later.
Later.
It's
Right.
too early.
Yes.
After some arguments, Mr. Das, learned advocate for the applicant, for the petitioner seeks permission to withdraw this petition in order to approach this court later when this situation so demands.
Obliged.
Instead of withdrawn to the Liberty Court.
Right.
Daily list item 7 for admission.
Small issue is involved here, Your Lordship. The mother of the appellant, Your Lordship. She nominated the appellant, Your Lordship, as a nominee, Your Lordship, her nominee, Your Lordship. And while issuing that letter, Your Lordship, she wrote Binapani Cooperative Samobai Samiti Limited instead of,
That is not a big issue. The issue is something else.
but Your Lordship, the
The
honorable
matter was reconsidered by the special
general meeting, Your Lordship.
general meeting. And special general meeting, the two other brothers who are not even part of that,
Lordship.
they appeared and they said that perhaps there was some foul play because the mother was not in a good health. And you were there in charge, you were in a position to influence her. And there was no reason why 32 years old or 25 years old nomination would be done away with. So they decided that no, respondent number 9 should be allowed to remain member in place of the mother.
That is by the, but Your Lordship, ultimately, Your Lordship, shareholder was mother, Your Lordship. Mother nominated me. There is no dispute about that.
Nomination.
And the managing committee, Your Lordship, managing committee accepted it
That,
during her lifetime.
that's all right.
During her, and the honorable single judge has,
Has been found. We don't find any.
honorable single judge has not gone into that, Your
Mr.
Lordship.
Thakur, tell us any rule under the Cooperatives Act which says that no, it cannot be done.
No, Your Lordship,
No, we will go by the primacy of the decision taken by the annual general.
rule says, Your Lordship, it is the managing committee who was to accept it, Your Lordship. And managing committee during the lifetime of my mother, Your Lordship, accepted it.
You've said that, we understand that.
And
But later it was not accepted.
under the rule, Your Lordship, it is the managing committee, Your Lordship. And managing committee accepted it. Subsequently, it was, Your Lordship, the annual general meeting, Your Lordship. And Your Lordship will kindly see the judgment of the honorable single judge, Your Lordship.
There is no supersession. Tell us any provision where one nomination without that being recalled the other nomination. And this nomination appears to be post haste. I mean, the mother was in bad health and she.
That's, Your Lordship, that's a, Your Lordship, finding of fact that will have to be decided by some manner, Your Lordship.
Therefore, you are raising a question of fact which cannot be decided.
No, I am not raising a question of, Your Lordship, may kindly come to para 26.
Do you dispute that respondent number 9 was nominated much before?
I am not disputing that, Your Lordship.
So
He
where is
was-
the order of recall of that nomination?
No, Your Lordship,
In place, let us see the nomination letter.
Lordship.
Let us see the nomination letter. Why do we get into all this controversy?
Page
Now, once
82,
it has
Your
been
Lordship.
decided by the lead single judge, we agree by it.
No, Your Lordship, largest single judge, Your Lordship.
Show us the nomination.
Lordship, page 82, Your Lordship. It's very clear, Your Lordship. By implication, Your Lordship, his nomination has been
Due
withdrawn.
respect, I beg to state that earlier my youngest she refers to it, but no, she refers to it. Anyway, you respond. You are for
Lord.
number 9.
No, Your Lordship, I agree for the department.
Let notice be issued as a report. Late Kamala Devi, the mother of the appellant, had nominated him as the person on whom her share in the cooperative society would devolve after her death. This, in fact, was in replacement of an earlier nomination made by her decades ago in favor of her younger son, Bipul Barua, bracket respondent number 9. It appears that the nomination was accepted by the board. The later nomination of the appellant was accepted by the board. But in the annual general meeting, which was held in May 2022, the board's earlier decision no, sorry. What have I said? It was replaced by an earlier nomination decades ago in favor of the younger son, Vipul Barua, respond number 9. There was initial objection of the board in accepting the nomination of the appellant on the ground of there being a minor typographical / clerical mistake in the name of the society. However, such objection of the board in accepting the nomination of the appellant was rejected by the annual general meeting, which was called in May 2022. No, there is some confusion. No, board accepted it first.
Board accepted it first, your lordship, then your lordship, after the death of my mother,
Board first accepted it, but the AGM rejected it.
LGM rejected it. Then your lordship, I came before this
You challenged it.
challenge it. Then the matter was remanded to the register.
What did I say? What did I say? We'll strike it off. We'll dictate it afresh. Take on. We have heard Mr. S. Borthakur, learned senior advocate for the appellant, and Mr.
G. Bodley.
G. Bordolai for the cooperative department, standing council cooperative department. Late Kamala Devi, while she was still alive, nominated the appellant as the person on whom her share in the cooperative society would devolve after her death. This, in fact, replaced an earlier nomination made by her in favor of the younger brother of the appellant / respond number 9. The managing committee of the society, through the board of directors, accepted the nomination of the appellant sometimes in the year 2021. Shortly thereafter, Kamala Devi died. When the aforenoted nomination was attempted to be implemented, when the aforenoted nomination / transfer was attempted to be effected, implemented, the same was objected by a decision of the annual general meeting in May 2022, solely on the ground of the nomination letter in favor of the appellant containing a minor typographical / clerical mistake in the society's name. The name of the society is Bina Pani Cooperative Stores, Bina Pani Cooperative Stores Limited. Whereas in the nomination of the appellant, the name was referred as Bina Pani Sambai Samiti. The decision of the AGM was challenged by the appellant before this court when a direction was issued by this court to approach the registrar of the cooperative societies. Next paragraph. The zonal joint registrar examined the nominations, examined the nomination of the appellant and overruled the objection of the AGM, and further directed the society to hold a special general meeting to decide the issue afresh. This time, the special general meeting upheld the original objection of the AGM perhaps on the ground that when such nomination in favor of the appellant was made, Kamala Devi was not in good health, good mental and physical health. Before the special general meeting, two other brothers of the appellant and respondent number 9, having nothing to do with the cooperative society, had also appeared and had supported the claim of respondent number 9, intimating the special general committee that the nomination was made about 30 years ago in his favor. The next paragraph, the district deputy registrar approved the special general meeting resolution. This was again challenged by the appellant, questioning the AGM resolution, semicolon, the resolution of the special general meeting and its approval by the deputy registrar. The learned single judge dismissed the claim of the appellant, holding that the nomination letter was defective because of wrong name of the corporate society and the power of the general body of the society to reject the same. It also weighed with the learned single judge that two other sons of Kamala Devi supported the nomination in favor of respondent number 9. Mr. Bhattakur, learned senior advocate, Mr. Bhattakur appearing from the appellant submits that a member has a statutory right to make, revoke, or vary a nomination at any point of time by a fresh nomination. Such a right was exercised by his mother during a lifetime, which was initially accepted as well. Only because of wrong name of the corporate society, the nomination could not have been rejected. A minor clerical error in the nomination letter ought not to, it was argued, override the animus decidendi. He has further submitted that the bylaws of the society provide that any decision of the managing committee can be challenged only by way of an appeal to the general meeting. And no such appeal was filed by anyone against such a resolution. Under such circumstances, the annual general meeting, the AGM could not have, on its own motion, reversed a managing committee's decision without following the prescribed appellate procedure. Yes, it has further been conveyed on behalf of the appellant that the ratification of the two other brothers of the appellant ought not to have weighed with the learned single judge, especially in view of there being no evidence on record that the appellant had influenced the thinking of the original member / date Kamala Devi in changing her nomination. Let notice we issued to respond on 9 on steps being taken by the appellant within a period of 2 weeks, both modes returnable August. In the meantime, the cooperative department, the London Standing Council for the Cooperative Department shall also indicate the stand of the department by filing a clear affidavit.
5-8.
Stand of the registrar,
5-8.
department / registrar.
Item 8.
Yes,
Yes, Lordship, there are two policy, Lordship. One rules, it is 73 rules. That is for director, the employees of the directorate, Lordship.
Assam Directorate Establishment Ministerial Service Rules of 1973.
Lordship. And next, Lordship, it is the district administration, Lordship. It is 67 rules, 1967, Lordship.
Both of you are governed by which rules?
Lordship, response number 1 is governed by the directorate rules, Lordship, and response number 2 is governed by the district
They say
administration.
that all of them, both of them were appointed under the same category. They are governed by the same rules, and in fact, that is the decision of the learned single judge also.
Lordship, so far, Lordship, there are two separate appointment order, Lordship.
Maybe all appointment letters are separate. They are individual appointment letters.
No, in appointment letter, in the appointment order for the directorate, Lordship, all the appointees, those are appointed in the directorates were issued in a separate order, and others, Lordship, those are appointed in the district administration, Lordship. That was in a separate order, Lordship. There are two orders.
Where have you made a specific statement that the one of the transferees is governed by the rules of 73 and the other is governed by rules of 1967? Don't try to conflate these issues by making different statements at different times. Where is your clear stand in the memo of appeal that both the transferees are governed by two different rules, and why so?
In the appointment order, it is not stated, Lordship.
How do we, where is your stand? Where is your statement? Let us see your statement that they are governed by two different rules.
Yes, Lordship.
And show us the rules, show us the application.
The statement is there, Lordship. It is
No, we understand that. Because mutual transfer is based on a policy. The
Lordship.
policy is that they must be in the
In the
same cadre,
same rules.
they must be in the same grade, they must be governed by the same rules.
Yes, Lordship.
Correct.
Yes, Lordship.
There could be a valid objection of the state, but you allowed that. No,
Lordship.
you allowed that, and then you're recalling after something dawns upon you.
Yes. In 73 rules, Lordship, it
Take
is.
the name. Who are these? Mustafizur Rahman.
Yes, Lordship.
And who is the other one? No. There was one.
Mosumi,
Mustafizur Rahman is the one transferee, and the second one,
it's a Mosumi Kolita.
Mosami Kolita.
Yes.
Both are petitioners, but yeah, Mosami Kolita. Who is governed by which rules?
Mustafiz is governed by the 73 rules.
73 rules.
Yes. And Mosumi,
So we are not finding any merit in it.
Lordship in,
You have explained it.
Lordship in 73 rules, Lordship, it is categorically stated, Lordship, the applicability. The rules shall be.
Swami, you argue like that, perhaps it will be dismissed straight away. You have to tell us why.
73
The
rules,
appointees are under the directorate.
Lordship.
Both the appointees are under the directorate.
No, yes, Lordship.
So
Appointment,
therefore, one rule will apply. Unless they have sought another department.
Lordship, this is a common recruitment, Lordship. That was.
So there's a
direct-
common recruitment under two different rules.
Lordship, the common recruitment for all departments. Lordship. After that, Lordship, the appointment was given by the directorate, Lordship.
I don't know. Still establishment with different term. Let's see the OM of the government. OM of 2025.
Yes.
Where do we get it?
Yes, yes, 55, page 55.
Page 55.
Same department of commissioner.
Allowed only for them at home to replace our development with the full nature and quality.
One department, that's what I say. Where has it been? Many, Show us your specific statement in the memo that one of them is governed by 1967 rules and the other is by 1972.
Yes, Lordship.
How can you make that statement? The statement must be correct.
Lordship, it is Lordship, see, the learned single just failed to appreciate that the.
Forget about the arguments and forget about your comment on the judgment. You tell us where is the statement that Mosami is governed by 67 rules or 73 rules and Mr. Rahman is governed by 1967 rules.
That is in our affidavit, Lordship, that was filed in the before the single judge, Lordship. It is categorically stated in our affidavit, Lordship.
No, do that.
In memo also, Lordship.
Both of them are being governed by the 1973 rules. Can you make that statement? File an affidavit that they are governed by different service rules.
And why?
And why? They are in the same grade, everything. I don't think they have any reason for us to interfere. We are giving you so much of time only for the reason that the applicability of that OM should be clear.
Yeah.
Yes, Lordship, the OM 73 OM Lordship, it is categorically
Make a
stated.
categorical statement here and don't rely on the affidavit which you have filed before the single judge.
Yes.
That so and so is governed by this rules, so and so is governed by that rules.
That was given, Lordship.
Understand? You will be making a wrong statement on facts.
Mr. Goswami.
Yes,
My lord is asking you to file an affidavit here.
Lordship. Lordship.
Specify
And what is
why-
this way?
Why is
got it.
applicable to whom and why are you saying that?
At least refrain from this practice of only making comments on the judgment.
Lordship.
You can canvass your case,
Lordship.
but then you have to make your facts very clear before saying that the judge went wrong.
Lordship.
We don't find it. On that score only we can dismiss your LPA. I mean this writ appeal, we call it LPA somewhere. That's not the way appeals are filed, Mr. Goswami. Raymond, this case concerns a mutual transfer dispute between two junior assistants / respondents working in the Animal Husbandry and Veterinary Department, Government of Assam. It appears that both were appointed on 1/6/2023. Pursuant to an office memorandum dated 1/1/2025 of the Government of Assam, which permits mutual transfers for grade 3 and grade 4 employees within the same department and directorate. But subject to the conditions that they are having the same grade pay, from a similar nature of posts / qualifications, and they've been governed by the same service rules. The respondents applied for mutual transfer, which was agreed, and government necessary consequential order was passed. Later, the department sought to recall such order on the ground that the respondents are governed by two different rules, namely Assam Directorate Establishment (Ministerial Service Rules of 1973) and Assam District Establishment (Ministerial Service Rules of 1967). The learned single judge rejected such contention of the department and held that both the respondents are governed by the 1973 rules and qualify for seeking mutual transfer because of they getting same grade pay and posted on similar nature of posts, apart from both of them being governed by 1973 rules. There is nothing in the memo of appeal to indicate that the respondents were governed by two different rules. Mr. J.K. Goswami, Mr. J.K. Goswami, standing counsel for the Animal Husbandry and Veterinary Department, seek some time to have clarity in the matter. He further submits that he be permitted to file necessary clarificatory affidavit before questioning the judgment of the learned single judge. Let such an affidavit be filed with clear averment that the respondents are governed presently by two different service rules. By the next stage, re-notify after 2 weeks. You have not executed the transfer. Then
I think they've cancelled it.
Yeah, they've cancelled it. Both of them are in this.
For 2 weeks.
Lords,
Otherwise, we would have given longer time.
Lords. Apply.
Yes.
May it please the last. Lord, the appellant's election as a president of the Anchalik Panchayat was put to challenge by way of a writ petition. And Lord, learned single judge was of the view that this is a matter which should assail by way of an election. To that extent is okay. Now, my Lord, section
Petition or delay for.
129B2 prescribes a limitation of 60 days. Admittedly, that is over. But the learned single judge says that the period which is pursued while pursuing the writ petition, that can be condoned.
I mean, how do you say that it is a violation of Article 323B or something, which says that
No,
nothing
my Lord,
can go beyond?
Lord, this is a covered matter. Our High Court judgment is there, my Lord, on the same point. And moreover, my Lord, the section 29(2) of the Limitation Act is also very clear. And how can, my Lord, a court of law either constrict or expand the scope of limitation, my Lord? And it's a special law.
If the Supreme Court would have done it, you would not have questioned this.
Because
When you
no,
respond,
even under, my Lord, there is a judgment of the Supreme Court. Even under 142, Supreme Court cannot do that. There is a judgment of
where
the
is that judgment?
Yes. That's a case from Gujarat, my Lord.
And what is this case from Patna, Hukumdev Narayan Yadav versus Lalit Narayan Mishra?
That's a case which was referred in our High Court judgment, my Lord. Our High Court judgment is 2014 5 GLR 442. Exactly on this point, my Lord.
Where do we get it?
Yes, my Lord. If a lordship would kindly come to para 21, my Lord, at page 447. On perusal of the scheme of the Act, we find that the Act in question, being a special Act, is complete code in itself and contains special provision of limitation for filing the election petition to challenge the election specified under the Act. Secondly, Rule 54 provides that rules enacted under Representation of People's Act could apply to the Act. Thirdly, Act does not make any provision to make the Limitation Act applicable to the Act, and hence, so long as there is no provision to make Limitation Act applicable, no benefit of Section 5 or Section 14 of the Limitation Act can be taken by the parties while prosecuting the election under Section 129B of the Act. And lastly, once the Supreme Court in 2 decisions have held
No, that's
that
true.
provision have no application.
But then where the provision of applying the limitation and duration also given in the Act,
Yes.
whether it can be extended, where is that statement?
No, my Lord, it can be. Last, because it said, that is why it is said, my Lord, unless there is a provision which says the Limitation Act is made applicable, then it is in that context only, my Lord.
Take it from, I mean, the General Clause Act says that under the unless it is specifically said that not beyond under no circumstance.
No, I think, my Lord, Section 29 of the Limitation Act will clarify that position, my Lord. Section 29, exactly. Yes. Section 29(2). Where any special or local law prescribed for any suit, appeal, or application, a period of limitation different from the period prescribed by the schedule, provisions of Section 3 shall apply as if such period were the period prescribed by the schedule, and for the where any special or local law prescribed for any suit, appeal, or application, a period of limitation different from the period prescribed by the schedule, provision of Section 3 shall apply as if such period were the period prescribed by the schedule for the purpose of determining any period of limitation prescribed for any suit or appeal or application by any special or local law. The provision contained in section so and so shall apply.
Appears for Abdul Munaf Singh.
I have instructions to appear, my lord, but I don't have a copy, my lord. My lord is considering passing a stay order, then I may be given a copy and we posted some other day, my lord, for consideration.
No, we're inclined to allow.
My lord, in that case, my
In
lord,
that case, therefore, we will definitely give you an opportunity of hearing.
yes. Very grateful. my lord.
The appellant has questioned us. We have heard Mr. K. Chaudhary, learned senior advocate for the appellant. And Mr.
Mohanty.
Mr. P. Mohanty, Mohanta,
Mahanta, my lord.
correspond number 7.
I'll file my wakalatnama during the course of the hearing.
He appears correspond number 7. The appellant has challenged a specific portion of the learned single judge's order dated 27/3/2026, passed in writ petition number 6405 of 2025. Paragraph. The appellant was elected as a member of the Pekamari Anchalik Panchayat and was later elected as president of the aforementioned Panchayat. This election was challenged by respondent number 7. This election was challenged by respondent number 7, primarily on the ground that the appellant lacked the mandatory minimum educational qualification. The writ petition preferred by respondent number 7 was dismissed on the grounds of maintainability. That the subject matter could have been raised only in an election petition under section 127 of the Assam Panchayat Act 1994. However, as noted above, the appellant is aggrieved by the concession granted by the learned single judge to respondent number 7, that if any election petition is filed, the time spent in preferring the writ petition would be excluded while computing the limitation period of 60 days in preferring such election petition. The appellant contends that more than 60 days have passed and now no election petition also can be filed by respondent number 7. Mr. Mahanta, who is yet to file his wakalatnama on behalf of respondent number 7, submits that he shall be filing his power and shall also respond to the petition and shall also respond to this memo of plea by the next date. Let that be done. In the meantime, the operation of the impugned part of the judgment,
My lord, in any cases, I'm not filing an election
granting
petition.
concession for exclusion of the time spent in writ proceeding from the limitation period shall remain in abeyance.
Lord, to consider it on the next date, my lord, the interim, my lord.
You file the election petition.
My lord, that has been stayed, my lord. I cannot file an election petition now. And there is no option for filing it.
There's a question of law which has been raised.
I cannot even file
You
a.
have taken a
263 application.
you have taken a calculated chance by approaching report.
Next, we have given you a shorter date, 2 weeks. Doesn't matter. 70 days, 80 days.
No, the next date and
This,
endeavor may be.
if we condone, then this part also shall.
The only issue, my lord, I cannot even file a 2263 application because I've already appeared today. So that is the reason, my lord. Only next date, lordship would have heard me and passed the interim
Nothing
order.
unfortunate. That was a good ground. You should have straight away approached the election. I mean, if Mr. Chaudhary does not have the requisite qualification, it would have, his election would have been cancelled.
The next date and endeavor may be made,
Because
my lord.
the normal advice of everybody here appears to be to come to court under 226.
There's a statutory provision, my lord, under the Panchayat Act.
Anyway, you respond, we'll see.
You are coming under disqualification. That has been clarified by not more than 3 judgments recently.
I'll address, my lord.
Hello.
Short date, 2 weeks.
22 seconds.
May I please, your lord, during the appeal, appellate, participating in the bidding process and being the high leader,
Yeah, this one. Lordship.
your lordship,
Came off.
similar, same issue.
The case where Bodoland Territory.
Yes, yes.
Says that you cancel this,
Yes.
cancel this settlement and appoint him.
Yes,
without any
yes,
tender.
yes.
Same.
Yeah, earlier it was number 12, now it is number 13.
This fixed on 17.
Matter is fixed on 17.
Let this case. And then we come. Against the NIT issued by the Divisional Forest Officer on 25th of August 2025 for grant of mining contract for a period of 7 years, ranging from 2025 to 2033. The appellant had participated in the said tender and was declared the highest bidder. The bid committee recommended him, which recommendation was approved by the Secretary of the Bodoland Territorial Council, by the Bodoland Territorial Council. However, in November 2025, the additional principal chief conservator of forests, BTC, instructed the divisional forest officer to proceed with the Hauvani. In November 2023, the additional chief principal conservator of forests instructed the DFO to proceed with the issue of settlement of Mahal in favor of the appellant in accordance with 2013 rules. However, on an objection raised by one of the executive members of the BTC, a communication was issued directing for cancellation of the allotment in favor of the appellant and retendering the Mahal for allotment of the work to. Is the respond number?
6, Dinesh Boro.
To one Mr. Dinesh Boro, respond number 6. Let this matter be listed along with writ appeal number 136 of 2026. Ms. B. Bhuyan, senior advocate, appearing for BTC, accepts the notice and submits that she'll be filing requisite affidavit by the next date. WA number 136 of 2026 is slated to be listed on 17/6/2026. This case also shall be listed on the same date, along with the aforementioned writ appeal. In the meantime, the operation of the judgment shall remain in abeyance. The operation of the judgment appeal shall remain in abeyance.
Lordship, on the last occasion, the Lordship made a query whether the BTC has taken any steps regarding e-auction. Lordship, I have talked to the officials concerned, madam. They are taking steps. It's going already.
Not yet.
No, they are taking steps, I mean to say.
We have stated.
Item 11.
Your lordship.
Just a minute, let's go. The state, Mr. Counsel, you will meet the same fate. Any settlement, however, more card, any settlement, however, in the meanwhile, shall be subject to the outcome of this appeal. You should have pointed this out, no?
They are taking
You will not
steps. I know they have
process
issued
the
communication
appeal
after I
subject to the
told them out.
You can't decide, I mean, retendering at least, we will go by what you say. Maybe,
My lord.
but then retendering to us, to a known person.
Yes,
to a-
yes, my
to a
lord.
Named person, how is that possible?
Could go, my lord.
Say that we are deciding this case.
My lord. Regarding e-tendering, Lordship.
Yes. Let this
Lordship.
case be listed along with manhole wala claim. Mr. Nath, it's the same thing.
Yes, sir, this PI.
Where is that PI
25th, I think.
It was on 25th Lordship has been.
number? Let this case be listed along with
PI 36 or 26.
PIL so and so, which has been directed to be listed on.
Lordship, I have some interim prayers, lordship.
File your response in this.
Lordship, if you may kindly, I have some.
We are picking up it on 25. We have not passed any interim order in the earlier paper.
Item 12.
Your lordship. Lordship, this appeal has been filed because the learned
Why do you want that specific information in writing? You've got that information, correct?
correct.
You want a specific information in writing. I mean, of course, the process adopted by the legislative judge could be debatable.
Yes.
Could be debatable,
One of
but
the-
then you've got the information.
We got the information, my lord, but the improved order, it was restricted to only two queries, number 15 and 16. Whereas the.
Are there other queries also?
Yes, yes, my lord. There are total of 26 or 27 queries. And
Who appears, have you made the second appellate court a party? The secretary of the second appellate court is the chief. Yes, Lord.
Yes,
I appear for the commission. Chief Information Commissioner.
yes, lord.
But why don't you pass the order?
Yes, sir.
Lordship, the appeals are considered on a trivial basis, so at the point of time when they file the easily.
Is that the answer?
Lordship, right, because it is taken up seriously, other.
Take instructions. You say that the appeal will be disposed of, we interfere, and we say that on grounds of this, we are not interfering.
Yes, Lordship, Lordship will give us some time, we'll dispose it of, and that can be disposed.
When will you dispose?
Lordship will give us at least 2 months' time to dispose of.
2 months.
Yes, Lordship.
And two of your important queries have already been settled.
And your lordship, there was some penal provision as per section 20 of the act, which was not appreciated by the learned civil.
Information of this time. And what he needs to say is this, I mean, what's the standing counsel for the department? Which standing counsel? Standing counsel who appears on behalf of response number 2 and 3. Lower response number 2 and 3. The first appellate authority and the public employment. Second appellate authority is who? The chief executive. The appellate authority is the steering function division. The appellant had filed one RTI application in the month of January of 2025 before the PIO, namely the inspector of schools at Silchar, seeking detailed information about the processing of the file of his father and delays in grant of his retirement benefits. No information could be received by the appellant. Except for partial answer to the queries of the appellant. The appellant, dissatisfied with the incomplete information, preferred an appeal before the first appellate court, where also he was only provided with partial response. Namely, answer to only some of the queries, and not all of them, which according to the appellant were interconnected. The appellant thereafter preferred a second appeal under sections 19(3) and 20 of the RTI Act 2005 before the respondent number 1. But till date, the second appeal has not been disposed of. Under such circumstances, the appellant had preferred a writ petition before this court by WPC number 710 of 2026. It appears that at the motion stage itself, the learned single judge sought an information with respect to query number 16 and 17 of the RTI application. What did I say? From the Standing Council of Respondent number 2 and 3. So those queries related to the process, namely whether a retired employee is served with a copy of the approval order for provisional pension, and whether such supply of the approval order to a pensioner is mandatory. On the Standing Council informing the learned single judge that it was mandatory, the learned single judge concluded that now the queries of the appellant have been satisfied. No further order is required to be passed. The appellant questions such an order on the ground that there were still queries left which were required to be answered. the only option, instead of issuing a direction to the second appellate court, namely respond number one, for disposing of his second appeal, the writ petition was closed. Mr. So-and-so, Mr. D. Decker, learned advocate who appears for respond number one, submits that he shall submits that the second appeal preferred by the appellant shall be disposed of within a period of 2 weeks, within a period of 8 weeks to be counted from today. In view of such assertion made by the standing counsel representing respond number one, we close this appeal after modifying the order passed by the single judge to that extent. Namely, the necessity of the second appeal being disposed of by respond number one within the aforesaid period. The appeal stands disposed of. Highly obliged.
Item 13,
Well, 13 to 36 are same Malak. In fact, Malak,
Except 14.
14 is different Malak. In fact, one of the similar issues taken up by the Supreme Court is fixed on 25 2026 Malak.
When?
20 this month, 20.
All these matters, similar matters.
Malak.
And is there a judge? I mean, I was informed that there's a matter pending before the Supreme Court with respect to disability.
Malak.
There is a matter pending.
Supreme Court.
No,
Let all these matters. Numbers.
it's not it. No, that's it. This is that's it. Here in this series, that's it. 4 matters are different and that has been decided by the Honorable Supreme Court of February.
Instead of segregating.
They have not disputed in that. In this case, disability already gone.
Item number.
Item number
15 to 36.
14 is not.
14 is different.
14 is different.
13, item number 13 and 15 to
37.
15 to 36. 36. Let all these matters be listed after the disposal of the SLAC bracket C number 3680 of 2025. Preferable on then after the as a in view of the similar matter, in view of SLA C number 3680 of 2025 pending before the Supreme Court of India with similar issue, let all these matters be listed in the on so and so forms. Which are those matters?
Yes, item number 15, 23, 28, 15, 17 also.
15, 17.
23 and 28. These are, they have not disputed that they are not.
I have seen that they are also relied on judgment. They said on last occasion that this is covered.
Yes.
15,
15, 17, 23 and 28. Only if a date of effect, Lordship, giving effect. That is the issue. And Honorable Supreme Court has decided it. Okay.
15, 17, and 23 and 28 report, let these four matters be listed on June, on 4th of June.
Can it be after court? I have got some.
11th of June. 11th of June. Well, the other matters, your colleague likha tha, in view of the SLA pending with similar issue, let all these matters be listed in August. August 20.
17 August.
Not obliged. Yeah, SLA ka number rakhe. Have you followed what I have said?
Hello.
Item 37,
We'll come back after something. Mr. Das, we'll come back after something.
No, this is regarding the Kachari ruins. Sericulture department has just filed an affidavit, and they're in positive direction. They've built some ASI.
Yeah.
And the sericulture department has said that it will take some time to locate the things. Only they need the demarcation, so the demarcation order maybe.
For maintenance of monuments, all right, but on one day I learned from sericulture department advocate only, it caused loss of so many employment. Anyway, but then law has to be respected. When are you going to vacate?
We have almost vacated.
Hmm.
Only the immovable property there are some ballot.
Hmm.
So those ballot is under the ballot applicable. So we go through a auction ballot.
How long will it take?
But by 3 to 6 months we ask for our ballot.
They need demarcation and ASI need demarcation. The Lordship may kindly see some of the photographs appended in the affidavit filed by them. Very beautifully done by ASI.
My affidavit is in the process of being filed. I sent him a copy, but we are taking steps to renovate.
I'm just showing it. It will become a very good tourist spot.
Just give my copy.
Ballot we have been maintaining, the leaders have been maintaining.
No, we have. I mean, we really don't know. Otherwise, we would have given a fixed time limit. Only because I am sympathetic towards this sericulture thing which is being carried out. I mean, it was being run for about 60 years.
60 years back.
I remember the facts on that day. And now for these years.
On their own, they are saying they are going to vacate. And sericulture says they are going to maintain it as per law. That's what the affidavit says. ASI. They need is the what they need is the demarcation.
They are doing.
Yes.
Only also there is one.
Or we give them some time to
Yes.
take away everything.
Yes.
Again, Mr. R.K.D. Chaudhary, who led the justice of the general opinion, submits that the updated status report is in the process of being filed. So even otherwise, he submits that the place shall be vacated in its entirety by the sericulture department. Mr. Das, learned senior advocate, has shown to this court the manner in which the monuments are being resurrected. It is expected that by the next date, the entire protected area shall be vacated by the sericulture department. We give after 3 months. Let this matter come.
Demarcation may be done by the revenue department. That's an issue.
During this period.
No, not that.
During
Not
this
that.
period.
That is the
demarcation of the land also should be done by the district administration. List this matter for when you list this matter on sometimes in September. September.
7 September.
Yes.
Item 41 for admission.
Just. See the cat order. It's 31.
Lordship, it's
Page
30.
30. Page starts from page 30, hello. Order starts from page 31.
It's 30.
Page 30.
Where is the speaking order dated 19/7/2022?
Well, the speaking order is at page 72.
Is 72.
Page 72.
Lordship, come to page 133.
One for
Must have. Yes, Mr.
Hello.
See, well, this speaking order talks about a drop in your performance. That, but that has not weighed in your transfer. What has weighed is that you have 1 year left. It's a routine transfer, and you're a scientist posted at a sensitive posting. You should not be there for a long time. Number one. Number two, your medical conditions also are not such where interference is required. So, routine officer, go back to your home state.
But the leaving aside, what your lordship,
Lordship,
the-
he is in the home state.
His home state is here.
He is
but
in-
as it has caught your lordship attention regarding the performances of 2021, drop in the performance. But where that,
Wait, that is not the
well,
reason.
that's
for transfer.
basically
Analysis authority thinking that a speaking order should contain everything, therefore he has said all this.
Yes,
The member secretary.
but in fact, Malad, what has happened, Malad?
That could have gone wrong.
Malad, in fact, what has happened, Malad, this 2021 has a role, Malad, because why? Malad, after this project was granted to me, Malad,
What
there,
happens to what happens to
no, Malad, there, if your lordship is
SL
telling,
Abbas,
Malad, the,
Namrata, haven't we done?
Malad, leaving aside the, Malad, leaving aside the
Yes,
other,
you can see that in the last year of your last year of service, you would be given your home state.
no, that's not exactly like that. But the policy otherwise suggests if there is an ongoing project, Malad, that has to be taken into consideration. Now, Malad, my basic challenge to this, Malad, leaving aside the other grounds, Malad, which is a challenge to the transfer order, the medical grounds and the other transfer policies. Malad, the one ground which was primarily, Malad, I believe that was the prime ground for challenge.
Where did you take that ground?
Yes, Malad, that is categorical, Malad. Malad, page
He
60.
says that it has been concluded.
Malad, that is what, Malad, I have alleged administrative malice against the respondent number 3. Why, Malad? Because the respondent number 3 has misinformed the board regarding the conclusion of the project, Malad, and has facilitated the transfer, Malad. Malad, there was a conflict which had arose between the respondent number 3 and the petitioner, Malad, with regard to release of the fund. And he was throughout cautioning the petitioner that he would be transferred if he doesn't continue with the project without the fund. Malad, that's my categorical pleading in the, and Malad, the Honorable Tribunal, with all respect, Malad, has not dealt with that issue. Malad, my primarily, Malad, that was the ground that because this project, Malad, imposes a penal liability upon me, Malad. And while undertaking this project in 2 years, Malad, I have done 2 patents. Which, Malad, in my respectful submission, Malad, the invention which we have done, one has been patented, one is for pending for patent registration. These are the 2 machines, Malad, which are useful for the proper completion of the project. And the beneficiaries, Malad, who would be benefited by this project, there has to be, as per the research methodology, he has to throughout with coordination so that they can use that machine. And I've also categorically pleaded, Malad, one thing. There is no, Malad, though the authorities have said that I can be replaced in the project, but till date, Malad, no PI has been appointed. No PI is also appointed, Malad. I am the only person who has been undertaking this project.
Fund by the authority, not by.
No, Malab, the bond says authorized signatory. And I have executed
If
it.
you go to page 81,
My lord.
it's not to individual to you, it's to the institution.
No.
Institution.
If your lordship kindly come to page 86, Malab. Page 86, Malab, for a moment. Serial number 12.
9 kilometers from Coimbatore, Tamil Nadu.
He wrote
Hero.
40 kilometers.
He is traveling
Now,
the
Malad,
same
these-
distance here also.
But
More than
traveling and all, that's not the problem, Malad. The problem is, Malad, by this transfer, I have not absolved from the penalty clause, Malad. But in the clause.
Penalty is to the institution.
No, no, Malad. Your lordship kindly see page 86, Malad. Serial number 12. The authorized signatories to the bond. And I am the authorized signatory of the bond, Malad, where because this is the project
All the members of the executive committee shall join.
and all the members of the executive committee. One, Malad, one signatory is I. Because this project was,
Big defense for you, know, that you've been transferred.
Malad,
That'll be a ready, in fact, you should get out of your own choice.
but
You should get out of that place. See, look at this. You take health grounds. You take the ground of your last year in service. You take the ground of your being a scientist of outstanding performance. None of it has been found to be correct by the authority member secretary. He says that you are a good officer, but you're not as good as to become indispensable for one particular.
so the
place.
same authority
And
has-
you're such a good scientist. You should not be allowed to remain at a sensitive place for a long time. Go to Tamil Nadu, do something for that institution also.
if your lordship kindly come to page it.
Prime officer
I
appears-
understand, Malad.
Prime officer appears, I don't know why.
Malad, I'm in
Secretary
fact
had to
conscious of
write-
the fact, Malad, that
Why member secretary had to write about drop in performance? And why did he write that which is holding us back from dismissing a petition straight away?
Malad,
But
the
the fact of the matter is that the order of transfer of 2020, which
22.
22, and you're
No, the case went on till 26 now.
In the meantime, I thought it's in the meantime.
no, Malad,
In the
the-
meantime, you are approaching to a secret.
nothing. We are not finding
Malad,
one ground to be convincing.
Malad, the authority is not acknowledging.
Soft handling this only for the reason that he's a scientist, he's about to retire.
And Malad,
Otherwise,
the effort of
otherwise we have directed that please join the place of posting or else other administrative measures will be
Malad,
taken.
that other administrative measure has already been taken now, by now.
You are very rigid.
Malad, the problem which lordship will kindly appreciate, Malad, the
What is-
authority is not
what is-
acknowledging.
Where have you stated that this statement by the secretary that the work is over is incorrect?
Malad, please. The lordship will kindly see,
Respond to this petition.
Flush.
Respond, we are not getting persuaded. Maybe a good scientist,
In fact, my suggestion
but then his administrative capabilities are doubtful.
that is there. By now, he has attained around 50,
59.
58, 59.
59. He has
So,
10 months
one
He
left.
can go and join and file an application seeking to his choice posting. Because there is a clause. And again, he can ask for his choice posting.
Would you give him?
That is for the authority. That's the law.
How many?
Because
1
now
year?
this
10
litigation.
10 months.
He basically
Mr.
want to complete that
Mr.
project. He basically wants to complete the project.
Mr. Chaudhary, you have an instruction whether he's joining and filing an appraisal.
If that
considered as-
satisfies the organization, whether he goes, he accepts it, he goes, makes a request and at least for the rest of the period you transfer it. Of course, we are not putting, this is no bargaining counter or something.
Thing is, this litigation went on for 4 years and that has come handy for him.
And all this while his transfer order remained stayed.
No, no, it was not.
It was nothing.
It was And therefore, he has faced the discipline proceeding also. But he's only concerned.
But how are you continuing there? How are you getting your salary there?
No, he's not getting anything. what he wants to, what in fact, when I spoken to the petitioner also.
Without interfering, you file your response to this. Take it.
If you have not complied without the stay order.
In fact, I've spoken to him like with this, what his concern is, that he has, during the completion, during the
This
project.
option is what has been given. by
Malab,
Mr.
that-
Chaudhary.
that
You
perhaps,
do
Malab-
that, you are closing.
Yes, that perhaps,
Take instruction. Question. The petitioner a scientist is aggrieved by an order of transfer dated 27th of February 2022, issued by the Joint Director Administration, Central Silk Board, Ministry of Textiles. Transferring him from RSRS Boko to Research Extension Center, Central Silk Board in the state of Tamil Nadu. The order of transfer was contested by the petitioner on several grounds, but primarily on his health. When nothing found favor, when these when the department was insistent that the petitioner must join the place of posting. He approached the High Court seeking cancellation, seeking setting aside of the order of transfer. This court relegated the matter to the authorities of the department to reconsider the case of the petitioner, including the grounds on which he was resisting, or the grounds on which he is resisting the transfer, and pass a speaking order. A speaking order was passed rejecting the request of the petition. So this was again challenged by the petitioner before the Central Administrative Tribunal, Gauhati bench, which found no reason to interfere with the order of transfer, which was passed 4 years ago. And because of the petitioner not having joined his place of posting, he has also been undergoing disciplinary proceeding and is left without pay. Today, the order of tribunal is being questioned on the ground that the tribunal did not look at a special fact in favor of the petitioner that he remains the principal investigator of a scientific project which was sanctioned by the President of India and funded exclusively by the Department of Science and Technology. And the project has not yet been concluded. This contention of the petitioner does not appear to be correct, as the matter was addressed by the authority, namely the member secretary of the board, who had opined that the project about which the petitioner is concerned has already been concluded. The counsel for the petitioner, however, submits that this was wrong information and the project still remains inconclusive. And has further informed this court that there are penal provisions for leaving such projects of high importance to be left unfinished. Since the petitioner has only 10 months to go for his retirement, he submits, that the tribunal did not consider the case appropriate. We are surprised that an order passed in the year 2022 was neither withdrawn nor stayed, but still the petitioner has been contesting such order of transfer till date. Ordinarily, this would have entailed a serious departmental proceeding against the petitioner. The land counsel for the petitioner submits. Are you ready to go and join?
That instruction I'll have to take.
Land counsel, leave it at this. Mr. R.K.D. Chaudhary, Learned Deputy Solicitor General, to take instructions in the matter and come back to this court by the next day. नहीं बस ये ले लेंगे उसके मत है ना नहीं करेंगे list this matter up to 2 weeks. You are not interested in your salary, abandon the job. Don't spend on litigation. Now, but I'm getting second thoughts of even recalling this order. Why should we even interfere? I mean, let me dismiss this.
Let it be let
it be dismissed. Unnecessary. I mean, this is showing unnecessary indulgence.
Well, in fact,
Only because you're a scientist, somebody coming and saying that he's a person working on the borders. Somebody will say that he's
Your conduct.
Apparently, the conclusion which they have said that the project is concluded.
Be a ground for us to interfere.
That is, my lord, after my transfer. After my transfer, they took a board resolution saying that it is concluded.
Mr. Kaushik, whatsoever, you without a stay order, you continue without salary, facing a departmental proceeding. At this stage, why should
No. We are dismissing. Your conduct. Sorry. We are blowing hot and cold. But then it appears to be rather strange. You're not interested.
I would request a cold today at least.
Do you have an instruction?
I'll have an instruction.
Take instructions, we'll get back, strike off. As prayed for on behalf of the petitioner, let this matter come up for consideration next week. Take instructions. Now, that would be highly unjustified. I mean, whatever we have dictated. Why? Who are you? You're not Abdul Kalam Azad, are you? I don't know why for 5 minutes before we were thinking in your favor. See, from 22, you have been evading this transfer. There is no stay order, nothing of the kind. Why shouldn't the cost be imposed?
At that point of time, he could have filed an application today that please take me back to Gauhati.
Mr. Kaushik, take instructions. You tell your client that the court has taken very serious view of the matter, that for 4 years, the transfer order has not been rescinded, it has not been withdrawn, it has not been implemented. This is something which speaks badly of the decision-making authorities also. You should have been thrown out of service, notwithstanding and regardless of your competence as a scientist.
I'll get back.
And this, what is this self-acclamation? Why did I go so soft in the beginning? I really don't understand. I thought that there was a stay, yes. Why did we go soft? We should have started shouting in the first instance. No, nothing, no matter, dismissed. Anyway, take instructions, come back next week. We will either you withdraw to join. In that case, we might make a request to the Deputy Solicitor General to intercede with the government, to intercede with the department, that he may consider your request for home posting in the last leg of your career favorable. That's all. Otherwise, we must tell you beforehand. It's for cautioning you, we want to impose cost. I am surprised at my thinking 5 minutes ago.
Because of this technique.
No stay and you're continuing and you're litigating.
And you are facing departmental procedure.
Court is seriously contemplating of awarding a cost of 50,000.
I'll get back to you. 21.5. Next week.
You,
21.5.
you tried to, I mean, not you, your client. He has tried to confuse the whole issue. Something which was never done, and how could that order be passed that you consider it again? And if that was there, there was temporary stay, that till such time final order is passed.
That was in the writ court.
That was by the week.
That was in the writ court.
Writ.
But order was passed when? Just a minute. Order was passed when? Speaking order was passed when?
Page 81.
That was on 19/7/22.
22.
So 4 years.
Stay that you get into stupid.
And you did not get any stay order in the calendar.
No.
And when did you file the petition? Oh, wait.
Not,
22.
immediately after the speaking order.
Maybe I can explain our thinking process because you said that President of India had handpicked you to be a scientist and some fund was allocated. That must not be wasted. So all this made us go soft in the beginning. Otherwise, we don't interfere in orders of transfer. I'm still not satisfied that I should leave it today. I mean, I want to conclude it today by citing all case laws, starting from KL Pass.
Let me have one opportunity
Opportunity to do what?
to get an instruction.
Not
Right? No, perhaps not to all.
As straightforward way of the petitioner, let this matter come up for consideration on next week.
21.5. Grateful.
And please, Mr. Chaudhary, remind me on that day.
Yes. In fact, I personally, I did not know that he did not have a stay. It came out from his
After why we were going so soft.
It came out from his mouth.
And only because he is a scientist and he is handpicked by President of India. That information also appears to be suspect. He must have got that project in his capacity as a scientist posted there.
Not specific.
No, but 2018 he was awarded as a patient.
And a scientist like scientist of such repute will not behave like this. Would whine only for the ground on the ground of his being transferred to Tamil Nadu. Yes.
Item 39 for hearing.
If I'm appearing on behalf of RDB Damage CGC, some health issues in Kolkata.
RDB.
RDB.
On the ground of
May I
indisposition.
please, Your Lordship? Lordship, I am for the petitioner. What happened, Lordship, in this case, this is a serious allegation in nature has been leveled against me.
Seeking adjournment on behalf of RDP.
Personal grounds.
Lordship, but my prayer is that for last many weeks, couple of
Can we keep
months,
next
years,
Mr.
I've been
Yes, I-
without no what to pay.
The health issue with her brother's transplantation has taken place last week and it takes about 6 months. And she will be available in the next week.
On the ground of indisposition of MSR, they will let an advocate who has to address this court on behalf of the respondent. The matter is adjourned to. After 2 weeks. Yep.
Of June.
It's with respect to demolition of which, the entire building or only the offending part,
the unauthorized part.
unauthorized part?
Exactly.
That you have not done.
That I don't know why they haven't done yet.
Why?
Because they say just had an interaction with them. They said that they call for notification. They could not get any party because it is a scientific demolition will have to be done. The parties are from outside Assam.
So this is the, but these plea, how much it is tenable, I am in doubt. If they are not owing the court's order, it's a very huge thing.
But
And
there
then,
is-
my lord, your
there
lordship
is a
can be.
contempt petition also, as we understand. Now, who appears for the writ petitioner? The applicant in contempt case.
My lord, they are in know of the thing.
Have we issued notice in the
Nonetheless.
contempt case?
My lord,
Yes,
criminal
madam.
contempt has been issued and the charge also framed.
That is my lord still.
And what review he wants?
No, I review my lord.
Review, my lord, now your lordship, just your lordship kindly see at page 48.
Unless the contempt is purged, we are not touch this judgment.
Can I take your lordship to page 48? my lord?
No. Let Mr. Chaudhary come.
Yes, sir.
Now he has to, we'll discuss this review petition straight away, or we will keep it pending unless the contempt is purged. In the meantime, this can't be done, no? You hold the process of implementation of the judgment. And then in the meantime, you file a contempt, the contempt, suo motu contempt issued, and then you come for review of the order. And what review? What is the prayer made by you?
An observation. What my learned senior counsel was pointing out to page number 48.
What review do you want?
Lordship.
Tell us. Forget about what Mr.
Lordship,
Datta was pointing out.
Regarding the setback of the permissibility, around how much of the land can we use? The judgment, the review judgment, what we have been praying for, your lordship, for the setback limits, which was held to be 40%. That is not the case, your lordship. It is actually 80%, your lordship. 20% could be less. Lordship, page number 48, your lordship.
My lord, first time.
This is what.
Well, ask Mr. Chaudhary to be here. We can't wait for eternity for him.
Lordship.
Let this matter, let all these matters come up for consideration. Or we are fixing a date sometime in July. In the 24. 24. 24. 8.
Obliged.
Absolutely.
Item 1 and 2.
I'm sorry, I was not here when you just.
Mr. Chaudhary,
Lordship,
tell us.
this review has been filed, Lordship, simply on the ground that a judgment passed by the Honorable Supreme Court, which is dealt with the matter that was not brought before the Lordship.
And what does the judgment say?
Lordship, the 11 paras are at page, Lordship, 83. Para 17, 18, and 19, Lordship. It said that court ought to have left the matter to be decided by the authority for relaxation under CCS pension rule 88. That is what this Supreme Court judgment has said, Lordship. Lordship, may kindly come to page 83, Lordship, paragraph 17.
No. So what does it lead to?
Matter relates to the claim of pension.
Correct. So these two respondents, the respondents here, the employees.
They did not have
They did
10
not
years
have
of
10 years of qualifying service for pension. Correct. So one had 9 years, 7 months, and one had 9 years, 8 months.
8 months.
So that would be taken care of by 49.3.
49.
So this relaxation is under a situation when 49.3 does not operate.
Lordship, this has been interpreted, Lordship, in this judgment, Lordship.
Yeah, tell us, no.
Lordship, paragraph 17. Lordship, may kindly come to page 83.
We are at page 83 now. Read para 17.
Lordship, it is also the respondent case that under clause 49.3 of the 1972 rules, if they had served more than 9 years and 3 months,
in regular employment, they would be entitled to have additional period completed for the purpose of quarantine service, said Rule 43 is quoted lordship. Arguments were advanced that if within a period of 1 year an employee had served more than 6 months, then the total employment term ought to be completed as twice the period of 1/2 year in 2 branches, and 1 year ought to be added to the service. But on a plain reading of the aforesaid rule, in our view, such an interpretation cannot be given. The rule contemplates one-time benefit in case of service of more than 3 months in fraction of a year. Rule 88 of the said 1972 rules empowers the concerned ministry or the department to relax the operation of any rule to prevent undue hardship in a particular case. This provision is embodied in Rule 18 provides full to 3 months. Exercise of power under the said rules, however, comes within the decision-making domain of the.
Once again, fraction of a year, so 3 months is left for qualifying fellows and above, shall be treated as completed 1/2 year. And reckoned as qualifying fellow. No. This doesn't apply. See, look at 49.3 first. What the Supreme Court judge was dealing with was, shortage of 9 months. Shortage of 9 months. Now it says in calculating the length of qualifying service, fraction of a year equal to 3 months and above shall be treated as completed 1/2 year and reckoned as qualifying service. What does this mean? 1/2 year means fraction of 3 months would be treated as 6 months. 1/2 of the year is 6 months, right? So if the period which is to be condoned or consumed or appear or to be relaxed is 3 months, then it will come to 6 months. This is the rule with respect to relaxation. But here it is a one-time affair. So in this context, the Supreme Court says that here, if say somebody even with the aid of 49.3 does not qualify for pensionary benefits, in that case, this would be a one-time affair only. This can't be made use of
Each and every time.
at every point of time. So there, Section 88 will come into play.
And
how does it?
And this has been left in the wisdom of the
Correct. So
authority.
where does it come in the way of the decision rendered by a division bench of this court wrong?
The
Or
matter ought to have been left to the authority for a relaxation under clause as rule 8.
that is with respect to 88, power to relax.
Power to relax.
So that should have been left.
That should
Now,
have been left.
why can't we understand it like this? I mean, Mr. Chakravarti, please apply your mind to it. Now, 49.3 does not leave room for any, discretion in the matter. 49.3 does not leave any discretion in the matter. Now, if by application of 49.3, fraction of a year is converted into 1/2, and then again something has to be done under Section 88, this is what the Supreme Court said, that this can't be done. This is a one-time affair. Now here, in the fact situation of this case, this is how we understand. 1/2 of each year. So here 88 was not called upon. 88 was not required to be invoked. It was only with respect to 49.3, which an employee gets it by virtue of the operation of the act, where there is no discretion in the matter. Like in many services, suppose the date of birth, the date of retirement is 2nd of October. The employee does not retire on 2nd of October, but the entire month is taken as a service period. Right. Likewise, so here the Supreme Court was in ceasing of a matter where the person concerned had completed 9 years and 3 months in regular employment. Here it is like, this is how I if we interpret it in the manner in which you have projected it, it would make one of the provisions redundant. So far as employees are concerned. I think we have made our point clear to you. Reject your review. Anything else that you wish to argue?
That's only, and moreover, Lordship, the GDS were outside the civil post, Lordship, and the GDS rule says that they will not be entitled.
That is not, this is something the what, and this also was with respect to, just a minute. Just a minute. This is a review petition, no?
Right, so the matter before the apex court doesn't appear to be similar to the one.
There was also shortfall of, there was a shortfall of.
Shortfall, but how many months?
Lordship, that
This was 9 years, 3 months. I mean, we have not gone to that.
the chart has been given.
I have completed 9 years, 7 months.
We are not asking about you. We are asking about the
Lordship, the chart
respondent
is,
in the Supreme Court.
Lordship, chart has been given in page 63, Lordship,
60.
from 62. It should be 65, Lordship, 65. Various appeals were taken together, Lordship.
7 years, 2 months, 9 years, 5 months. Nowhere it is 3 months or less. 9 years, 4 months. 9 years, 6 months.
9 years, 7 months is the very lot.
So 9 years, 7 months will fall in a different category.
Lordship.
And there is no 9 years, 7 months.
9 years, 8 months, 16 days is also there. Serial number 13, Lordship. Serial number 13, Lordship.
What do you have to say to this, Mr.?
My lord, I have completed, my lord, 9 years, 7 months and 5 days.
That we have understood that. So you tell us whether this judgment applies to you.
No, no, my.
Why?
My lord, because, my lord, in the judgment, my lord, at page, my lord. Page, my lord. Can you see page 16, my lord, para 14. Their contention is there, my lord. The petitioner bids to state that as the matter involves financial implications and there is every possibility of other employees may also start to claim similar benefits of well-being exemption beyond permissible limit. The matter was examined at several levels in Postal Directorate, New Delhi, and finally the instructions to prepare a review was given on 3/11/2025, and the matter was therefore handed over to the CGTV.
No, but just a minute. Pursuant to the order passed by the division bench of this court, which is sought to be reviewed, are you getting pension?
No, Lordship, just find the contempt. Contempt is also tagged.
Because it says that this judgment shall be operative in the event of central government or the postal department has already issued any order of pension to any respondent, then such pension should not be disturbed. In issuing this direction, we are following the course. In respect of others who have not been issued any order for pension, the minister may consider as to whether the minimum qualifying service rules can be relaxed in their case in terms of Rule 88.
This judgment which you are placing reliance on, is it perhaps with this issue whether the, what is that, GDS? The GDS can be equated with the regular service. Whether GDS, the service rendered as a GDS, can be counted as regular service.
In any case, there was a shortfall that 10-year service was not completed. And the highest one who has served is 9 years, 8 months, 15 days. As per this chart.
This is with respect to GDS and its relaxation. No. The respondents here were all regularized,
They are initially
but 10 years they did not complete.
shortfall is there.
And therefore, this is particularly with respect to persons who are regular employees of the department.
In this case also, they were extra department. Lordship is written, join as EDA. All the cases.
They may have joined as EDA.
And similar
but
there-
services were regularized.
Regularized
Extra
subsequently.
departmental agent, they say, but they were regularized.
Subsequently.
Subsequently is all right, but on the regularized post, they have served for 9 years in service.
Lordship, no. Lordship, just take the case, one case, Lordship. Serial number 1. He joined in 1970, Lordship, and appointed in Group B 98 and retired on 2008. Similar to a present case, Lordship.
Now, the judgment under review says that they were in regular service, full-time employee.
Not from the beginning, Lordship.
No, 9 years, 10 months, what have you calculated?
As a regular service.
As a regular.
Initially as a GDS. Similar to here, Lordship. Lordship, can you see the chart, Lordship? It's given, Lordship. When they join, when they regularize.
You respond to this petition. That you served on regular post for 9 years, 8 months. Both of you. Who is appearing in the other?
The other case has not been listed. That is review petition, Lordship.
Okay, let this case, in the meantime, you respond.
Review petition 28 of 2025.
Let this case be listed along with petition number 28 of Wednesday. So in the meantime, the learned advocate appearing for the respondent number so and so shall put in his response to this review petition. Also, it's whatever. Now, in that case, you can't hurt yourself on the contempt. The order, the Supreme Court judgment says that, otherwise, by virtue of the division bench judgment, pension orders should have been issued. You have not done that. Why?
We filed a affidavit in the.
When did you file this review?
Contempt, in the contempt also, Lordship.
You file your response. Have you followed, Mr. Counsel?
Mr.
Rahman.
My lord, in the contempt petition, they file my lord, reply, my lord, in my contempt petition.
In the
The
review,
review petition, you file a response.
My lord, I'll file.
You have to specify. Don't give us unnecessary history.
I'll
You tell us that you were appointed on which date, you were not regularized till which date. On regular employment, your services were rendered for so many years and so many months, and therefore you would be entitled for the rounding off of 1 year, rounding off half a year. If it is rounded off to half a year, then perhaps you get 10 years.
My lord,
In that case, there is no question of any discretion in the hands of the employer.
my lord.
It is 49(3) only. It is only in cases where your regular appointment is not there and your period as GDS or extra duty agency, that has to be counted. Then perhaps this section 88 comes into play. That's how we understand, and we would like to understand it that way.
My lord,
In that case, he does not have any case. But you'll have to respond to this
my lord, I'll-
and ask your friend who's appearing in the matter, in the other review, to also come on that day. Okay, it has not been listed, therefore he's not there. To be listed on that day. In the meantime, you file your response.
my lord. I'll apply.